Maintenance of status RFEs in the H-1B cat cases is the next $100,000 challenge.
Ooh,
Good
yeah.
evening, everybody. Sam Shihab and Brian Burke. We're going to spend 15 to 20 minutes to talk about what's coming next that's going to be really critical for getting on H-1Bs for the students and take questions after that. Brian, this is really the big one right now. We all know how vulnerable H-1B students are for challenges in the area of maintenance of status. This has been the Achilles heel really for H1B students, F1 students going on H1B
Yep.
for a long time. This year, however, might be the year that's going to be a serious challenge because everyone that's failed is going to equal a $100,000 cost to get this person back in the U.S.
Yeah.
Um, as you know, as a background, as of September 21st this year, a $100,000 fee is implemented subject to court challenge for any consular processing case applying for H-1B or where the change of status is denied.
Yeah.
So student in the United States, even though they have a better chance of selection because of this, they also have a higher risk of denial as because of the $100,000 as well, Brian.
Yeah. So I figure, if we're going to talk about how to avoid these problems, I figure you're going to talk about what the most common problems are. How do you accidentally break your student status? And I think where it starts is with unemployment. Basically, for those who aren't aware, you get an EAD from USCIS when you get your OPT or your STEM OPT, and they don't give you a rule sheet with it, right? But there are rules. Most important of them is 90 days of unemployment while you're on OPT, and another 60 days while you're on STEM OPT. As an aside, some people think that, if I just leave the United States, I'm not in the country, and thereby I can't be unemployed in the United States. Well, you can leave if you leave the country without a job, you're accruing unemployed time for while you have that OPT or STEM OPT EAD. Now, an interesting sort of ripple is that while you're on the initial 1 year of OPT, you can have unpaid employment, right? Whereas STEM OPT requires you to be paid. There is a requirement of 20 hours a week at all times, and for people who at least 20 hours a week for STEM OPT or STEM OPT. But let's talk about the elephant in the room that is unpaid employment. USCIS can be skeptical of unpaid employment. If you just say, "Yeah, I work for company XYZ," and have no pay stubs, they are going to be particularly interested in that because their unpaid employment is a thing, but there are rules about it. Basically, you can't, if you're just doing the work of an employee and not getting paid, that's kind of a problem. Is a short answer. There are sort of very unique rules for unpaid employment. They're governed actually by the Department of Labor. That essentially says that you should be, that you shouldn't be taking the place of an employee. Essentially, you shouldn't be doing productive work. There's a sort of a series of factors they consider. But I guess the short answer is, if you're being told, yeah, unpaid employment's okay, you got to think about it a little bit more than just being not paid and doing work for somebody. You
The
know.
other issue, Brian, is CPTs.
Mm,
So CPTs, especially the day one CPT school, has always been a target by USCIS for compliance.
yep.
And the requirement for a first day CPT, what is a first day CPT? Is a school that give you a curricular practical training and employment on day one of registering with the school. USCIS hates that, and while it is allowed by law, there are strict requirement that comes with it, and USCIS dives into these strict requirements for compliance. And this is going to be something this year is going to be a big deal. One of the requirement that a lot of time we find problems with is the attended classes in person.
Yeah.
So you must attend these classes in person. If your CPT is in another state, how did you attend those classes? So you have to prove that you were on campus at the required time for the required course, and especially if you don't live in the area.
Yeah.
So they need transportation,
Yeah.
evidence you were there, a sandwich you took at the street across on your American Express or Visa card, and things of that nature. Attendance record and log from the school can definitely help. Some school, Brian, allows for weekend meetings and
Seminar style. Yeah.
classes. And that's fine, but you have to be able to prove it. CPT programs also requires employment that's an integral part and mandatory component of your education. So it's
Yeah.
part of your education or similar to your education. They want to see that you have created this integration between that CPT employment and the courses that you're taking. And if you're not able to show that, that is going to be a problem in maintaining your status, which if you're not able to show your maintenance of status, you're not going to get your H-1B
Mm.
approval, Brian.
It's worth noting that those day one CPT schools, they have often have say experience with answering these RFEs. So I mean, they can usually help you out. But what the things you've highlighted, Sam, are so important. It's the record keeping. It's about the stuff that you keep, having those good records of your travel, of your attendance, of your doing coursework. Those things have been lifesavers when it comes to issuing that, or rather answering that RFE. So moving on from the CPT, one thing maybe you should generally understand is that what your obligations are. There is, your obligation to the school to always keep them updated as to what you're doing in terms of employment while you're on OPT, STEM OPT, CPT. We have encountered a fair amount of cases in the past where, oops, the school terminated my SEVIS record because I wasn't communicating with them enough, because I was in compliance, but I was busy at work and they were asking me for an update on my employment and they didn't answer. And the school has the power to terminate your SEVIS record. And basically, your SEVIS record is your status in the is your F1 status. Not really, but that's the way it ends up working out with USCIS. And if the school, basically keep in the good graces of your school, because if they go ahead and kill your SEVIS record, even for you know oops, sorry reasons, believe me,
Yeah.
that keeps guys like us who do appeals working. And I never want anybody to be in an appeal scenario. Is my
Yes.
my
Yeah.
short answer on that one.
The other thing, Brian, is discretion.
Ooh, yeah.
So discretion is when it comes to infraction that you've had a public intoxication incident, there's a police record, you've had some kind of a fight, there is some kind of a court record, a DUI, a criminal background, minor or not minor. USCIS can exercise discretion as to whether or not they should approve your change of status. And a lot of time, what we've seen is they are very active in reviewing the personal uh, criminal background of the applicants and issue biometrics notification to have you go down and give your fingerprints so they
Yeah.
can do a deeper look into your background. So if you have issues with background, that could you need to tell your attorney,
Yeah.
because there are ways to preemptively address it,
Yeah.
perhaps, or to quantify it for you, so you're not playing cat and mouse with
Yeah.
USCIS. So you know where you stand and what you need to do, and you make your life a lot easier.
Yeah, these things are real. I happen to have one of these. Literally, I can't show it because it has names and personal information, but literally in my hand right now. Those are real. And you, like you said, you can get it if you talk with an attorney. You can. So obviously, you worry about spooking an employer by getting an RFE about some sort of criminal thing, but you can get in front of these by at least being prepared to respond to them. And because the challenge of getting one of these discretionary RFEs is they'll say, well, you have this criminal thing and you got to show us why we should approve your case in spite of it. And the answer is there's some work to be done there in terms of getting good evidence of your being a fantastic, awesome person, and this little court thing they're bringing up not being a big deal at all.
It's not who you are.
Yeah.
It's a frolic,
Yeah.
right?
Yeah.
More so than it is the kind of person that you are. And good legal work can really make a big difference in these cases.
Yeah, I just this one I have in my desk right now. Basically, this guy got warning of that it's coming when he got a biometrics notice. I said, well, you know, basically you're eventually going to get an RFE or annoyed on this, and you're not going to have much time. So if you want to get started on it now
The
before you have that
the
RFE in
ones that
your
are
hands.
devastating, although they're very minor criminal offenses, is the scenario that I've seen is the I went to visit my friend who owns a liquor store, and I got behind the counter to help him out, and I got cited for selling liquor to a minor,
Yeah.
and now I have a criminal record.
Yep.
Not only do I have a criminal record, but I also have a potential work without authorization problem.
Yep.
And maybe you'll survive the argument on the criminal record. You were helping, you did not know what you're doing. But what the heck are you doing behind the counter, taking cash and running a register in your friend's convenience store?
Yeah.
These are very difficult cases to overcome because it really has a bad tone to it. It does, you're really kind of have more than one problem to deal with. So any of these things, trust me, they're going to come out. You might as well talk to your attorney about them and have your attorney be prepared and get all the record and see what's in there and what's not in there and how can we argue it and what would be the best way to survive that change of status request.
Yeah. It's a
Um,
$100,000 question for sure. Yeah.
Full course of study.
Yeah.
So if you've not taken full course of study, 12 credit hours, minimum 12 credit hours. And if your semester or two below 12 credit hours, even though the SEVIS record does not reflect bad record, bad history, they can declare you out of status by virtue of the fact that you had 11 credit hours.
Oh yeah, I've seen a case where basically in the past, I think it's an appeal I did. It's where somebody came to me, the school terminated this person's service record because they weren't in a full course of study as required by the law. Now the school told them it would be fine. There's email correspondence saying, oops, saying that don't worry about it. Go take lesser caseload. But because the school messed something up, that's, I guess it goes more into the SEVIS issue. But you're right, USCIS can delve into your student records to basically make sure that went to classes and studied in good faith. Yeah.
Yeah. So these are $100,000 change of status challenges, each one of them.
Yeah.
And what's going to happen is we're going to see a good likelihood of selection among students this year because I can tell you that the number of companies with appetite to file H-1Bs for $100,000 is very limited to non-existent.
Yeah.
That leaves the existing pool in the United States really a prime pool to take advantage of the 85,000 available plus or minus green card H-1Bs. Wonderful. That's great news for students. But trust me, USCIS is going to be waiting for you to make sure that you've maintained perfect status and there are no issues. And to the extent that there is an issue, bring it up to your attorney in advance. Not don't blindside the lawyer. They can help you. With time, we can do a lot better job than with very little time or in response to an
Very good
RFE.
point. Yeah.
Defensively is a lot weaker position than proactively for us.
Yeah.
So think about that. So
Okay.
that's the advice today. Brian, I know we started late. I'm not sure how is our audience. If there's any questions, I know
Yeah, we
there's
have some questions here
okay.
and some live ones. And as always, hit up our immigrationquestions.us if you have any questions during the week. That's the .us domain. It's a good domain. You should try one. Buy one for yourself. Anyway,
So that's
so
our domain, and we have questions that you can privately post there, and we will do the best
we'll
we can to
we'll
answer
we'll
as many of them.
try to get to some
Yeah.
some of them here for sure. But here's a great hardcore classic immigration question that we talk about a lot in this office. Hi, gentlemen. When your future employer files an H-1B transfer, do you need or should file a spouse's H4 for the I-94 expiration to match the new H-1B transfer I-94, or is there no need? Um,
Well,
we
yeah.
Go ahead, Sam. Sorry.
No, Brian, you go.
Okay. We recommend that you do so. Why? Because we don't really like having to do nunc pro tunc H4s for when you forget about the spouse's H4, H4 because you're happy and you're working and doing an H4 nunc pro tunc at the same time as your H1B extension with that company. That's my take on it anyway.
Brian and I just got off the phone
Yeah.
discussing a similar scenario precisely, and that's the reason we were 4 minutes late today. Wonderful people, and boy, the wife is mad about H4 being overlooked, expiration
Yep.
date overlooked, and trust me, USCIS has not been very generous. Um, Now, in their circumstances, they are lucky that there's good basis, we believe, but that's not the case everywhere.
Yeah.
Um, you, making the H4 and the H1B expiration date match makes your life incredibly easier.
Yeah.
And you don't want to get your wife mad at you, but she will be mad at you if you forget because she's not going to remember.
Yeah, this issue is so prevalent. We have it built into our internal H1B workflow at least 3 times. Reminders of this doesn't cover your spouse. This doesn't cover your spouse. This doesn't cover your spouse. You know, and because we have seen this scenario before, and somebody asked me that question. Technically speaking, your wife is required to extend her I-94 before her I-94 expires, but why not now? Is
Yes.
is my general answer there.
Yes.
So another one of these live questions. With the India EB2 filing date moving in March, and boy, that was a big move, enough to move us onto YouTube on Friday morning to do a special session, that's for sure. Can we expect filing dates to move into 2016 and October 2026? My EB2 priority date is December 2015.
We don't know. We don't know. I mean, I was talking to a gentleman, a client, and he has a 2016 priority date.
Mm-hmm.
And he told me, yes, everywhere I read, the projection is in October of 2026. My priority date, which is somewhere in 2016, is going to be there. That's what everybody's projecting. And I said, I hope you're right. I hope that's the case, but I don't know.
Well, I'm going to remind everybody how far the visa bulletin has made it for the India backlog. It has made it to, as I recall, January 1st, 2015. Right? That's as far as it made it. Right? And over the last couple of years, since it got there in like 2020, I guess it was, they've been approving green cards for people with dates before then and allowing it to slowly creep up. And beyond January 1st, 2015, nobody there has gotten a green card because their priority date hasn't come up. And if I'm going to imagine, a lumberjack, the area before January 1st, 2015, that forest, there's very few trees left, and it'll be very easy to move
More
until then.
opaque,
Yeah,
more opaque,
yeah,
more sporadic,
yeah,
more open, less
yeah.
cases.
But with January 1st, 2015, the dates just haven't made it there, and idea as to how quickly they can move the visa bulletin in what would be normal times again, being, going back to that classic move 1 week at a time sort of thing. I don't think the government knows what the volume of. Okay, maybe they have an idea. I guess they have reports they can pull, but I think getting big movement through the year of 2015 is going to be a big challenge because I expect it to be old school slow because there is large swaths of people who've gotten their green cards with those priority dates. I guess I'm sorry to be a downer, but that's what I think. You know. So another one of these live questions here, Samsir, and can you comment on academic H-1B extension?
Okay, so well, I think I can comment on H1B extension in general, academic notwithstanding, I mean, included. We are not seeing a great problems with extensions. We're getting cases approved, Brian.
Yeah, I would agree. The only, for the last year of this new administration, which has different feelings on immigration in general, I would say that we are still seeing H-1Bs approved with no sort of, not too many new and exciting trends. The only exciting trend is the same trend of, ooh, if we see a criminal thing in your past, we're gonna bring it up now where we might have not done that in the past. Yes, that's a new trend. That applies to the F1 changes the status as well as to the H-1B extensions right now, and that is a new trend. But I mean, what's different if you're an academic in H-1B in a cap exempt organization? I presume somebody's getting around saying The answer is,
Yeah,
boy,
yeah, no problem. I mean,
yeah,
they're obviously they're not cap subject,
yep,
um, and I don't think the president has any problem with them.
yeah,
They're still subject to the $100,000
yep,
dollars.
yep,
So maintenance of status is a big deal.
yep.
I find it difficult to envision a maintenance of status problem with many of these cases.
Yeah,
Um,
you
yeah,
realistically those the if again presuming we're correct and presuming this person's talking about a cap exempt, academic organization sponsoring H1B, those are sort of prestige institutions. These are state and university systems, that sort of thing. Meaning, I agree with
it
you.
could be anywhere. It could be private school. It could be small schools.
Yeah,
All the same.
yeah,
Academic is academic. So yeah.
yeah.
All right.
Well, so I'm gonna hit one of these other live questions here because we got a little bit of time. We got another 10 minutes here, Sam, before we hit our usual half hour. So, any chance of EB2 June 11th, 2015, Sam and Brian? Well,
Better than 2016.
yeah.
Six
So
months quicker.
I'm gonna go channel the wisdom, our sort of position which we seem to have adopted in the Visa Bulletin. There are two charts. Everybody knows there's the dates for filing and the final action, right? And Sam, we've seemed to have finally settled into that the dates for filing are a prediction as to where the final action dates will be in the foreseeable future,
In
right?
October.
Yeah, and yeah, and basically through October, because how can they really foresee into the next fiscal year? And it seems to me that the dates for filing should catch up to the final action dates as the year goes on. They should probably close the gap on those things. Thereby, I think it's really hard to look beyond the current fiscal year you're in the Visa Bulletin. Does that sound? There's a lot of Visa Bulletin between where we are right now in terms of final action dates and where this question asker is. I'd say it's not crazy. It's not absolutely insane, but 6 months in a year is essentially. I mean,
It's a
I'm thinking
big
about the
leap.
fiscal year 2027 to come. I'd say it's not crazy in fiscal year 2027 to think it could happen. 6 months in a year, presuming you get to January 1st, 2015 in this one, it doesn't sound crazy. But again, the dates for filing for India are only in August or November of 2014 for EB2. You're not even up to January 1st, 2015 yet. You know? Yeah. Crossing fingers for this individual, that is for sure. So I brought up our immigrationquestions.us portal, Sam, and I may have lost it here, and I'm going to have to just pull it back up again
Oh,
because
I can go
I
there
can't
too.
seem to find it.
Oh.
Um,
Hmm.
Oops. Maybe because I'm in the wrong browser. Hey, there it is. Immigrationquestions.us. There we are. Opened up the wrong browser window. Here we go. We got one here right from. That's a repeat of the one that's in there. So I have a couple from yesterday here. Let's see what we got here. I'm going to take this one down here. I am on L1A status, and my L1 7 years period will be over by December 3rd, 2026. Ooh. My priority date is January 16th, 2024, and my current date filing date is December 1st, 2023. Hoping at least the filing date will come current before my 7 years term will be over. My clarification is, can we stay in the USA with a pending I-45 status, employment status? Will I-45 be rejected if I didn't maintain the employment status while the I-45 is processing? So I'm going to maybe condense it down a bit. Everybody who's not aware, you get 7 years on L1A status. And it sounds like somebody has probably an approved EB1C I-140, and they're really hoping for their filing date to come up so they can basically move to have a pending adjustment and get an EAD. But the problem is, it's a great question of, will that come up before I run out of L1 time? And to answer the question directly, I would say you don't have to maintain, as long as you file while you're still in status, you don't have to maintain your L1 status while the green card application is processing. However, I'd recommend it that you do. But what can you do, Sam, when you're running out of L1A time?
So the question to me, Brian, is a little bit different.
Sure. Oh, okay.
Uh, if I did not maintain the employment status while I-45 processing,
Well, you mean,
so maybe lost the job or something like that. So no
okay.
longer the job. If you don't have the job and the I-45 is pending, you are not going to get the green card. Now, there is something called portability of the I-485, Brian,
Yeah.
and it's also applicable to L1As.
Yeah.
As long as you're moving to a different company after 180 days of I-45 filing,
Mhm.
that you're doing same or similar job classification to the one that was filed that you used for the adjustment. Now, portability and EB1C is not a normal combination,
Correct. But yeah, it's
uh,
allowed. Yeah.
but you can definitely argue it if that's the question you have.
Yeah. Well,
Um,
I want to come at a different angle on this. If you're worried about L1A time, what about H1B lottery? Now's the time to do it. I mean, I just literally made this recommendation for one of our clients here, somebody who has about maybe a year left on, maybe about 2 years left on L1A, and about 2 years until their priority date comes up, presuming the visa bulletin moves in a linear manner. And what I told her employer was, okay, we're going to cross our fingers that it's not necessary, but you should probably toss this employee's name in the H1B lottery this year, presuming you have an L1 job that would support a specialty occupation finding for an H1B. But if you're in a technical role like a software development project manager, for example, I think that's a good option for you as well. Get yourself in the lottery through your employer, hop on H1B status to ensure that you have continuity of work authorization. There you go. Yeah.
um, sounds good. I'll take that answer, Brian.
Okay. Let me see here. So this one is from these. We may have hit this one, but maybe it was last week when we didn't quite get to. So I think we may have gotten to this one, but it's it's a good question anyway, and I'll add it here. Oh, it seems like it's one we already actually did. It was about
Okay.
basically it's safe to
Travel.
travel in this
Yeah, in
current
this environment. Yes.
climate,
Yeah.
and there's that. So going back to the chat, I think we've covered all of our questions that we have for today, Sam, sir.
Yeah. Sounds good to me. Well, it's
Yeah.
perfect timing, so that's good. Thank you guys for taking a moment to listen to us. Hopefully, the H1B F1 to H1B is giving you food for thought and hopefully a successful H1B cap season for you guys. Take care and have a great rest of the week from Brian, myself, and the team at Shehab Burke. If you want to reach us, that shehab-burke.com is an easy way to get a hold of us
Yeah.
if necessary.
Yeah.
Have a great